Who is sharing the slides? Why am I seeing all of this?
Yeah, I'm trying to share my slide.
Oh, oh, okay. Let's see, is this your desktop? This is not your desktop, yes. This is our desktop.
My phone. Okay.
It's ours, not yours.
Okay, okay. So perhaps you have to be the one to share my.
Lucy, who's sharing the slides?
I think I'll need this too.
Why am I seeing all of this? Could you just click welcome? Click on the welcome.
Perhaps I need to.
NSCQ will share your slides. Once it's time for you, they will give permission to share your slides.
Okay. So perhaps we then need to close this. Okay. So.
Good
morning, my lord.
Good morning, my Lord Emeritus, ma.
Good morning.
Honorable Justice Phillips, good morning, ma.
Morning. Can you hear me? Can you hear me?
Yes, ma. Loud and clear.
Very good. Good morning.
Thank you,
it's 7 minutes past 4 in the morning here.
Whoa, so sorry about that. Sorry,
that's fine.
Thank you. Thank you for the privilege. We are most
appreciative. It's a pleasure.
Thanks a lot.
Okay. Good morning, my Lord Chief Justice Emeritus.
Good morning.
How are you, ma?
I'm fine. Justice Lawal.
Yes, my Lord, ma.
How are you, my dear?
Good to know that you are fine. I'm okay. I'm fine, ma.
And the family?
Fine, my Lord.
Good, good.
Family is fine, my Lord.
Good. We give God the glory.
Thank God, ma. Thank God, my Lord.
Koshe.
Adupe, ma.
Koshe.
Adupe, ma. Shalali.
Good morning, everyone. My lords, we're already in the webinar section.
Wow, okay.
Yes, participants are already logging in. We already have 53 participants. Good morning, everyone. We'll just spend the next 1 minute to allow more people to log in before we start.
All right, that's good. I was greeting my sister Judge. I thought I saw her for a minute.
Yes, my Lord, she's there. Yeah. She's there with you.
Yeah, how are you, my Lord?
Morning, my Lord. How are you?
I'm fine.
And the family?
I haven't seen you for a long time. Well, okay. You've been away for some time.
Yes, yes.
Yeah,
I thought I saw you at the airport once when you were traveling, or it wasn't you.
Yeah, but I came back for it.
How are you feeling now?
A lot better.
A lot better.
Okay.
How's the family?
Yeah, fine. I came back because of them.
Children. You know, children is a lifetime job. Then you have grandchildren on top. It's a lifetime job.
Even when they are married with their own children.
Okay.
You are still mommy.
Good morning, my Lord Emeritus. Good morning, my Lord Emeritus. Honorable Justice Phillips, Honorable Justice Uzokwe, Lenesuk, Mr. Agbola. Welcome everyone to the Nigerian Arbitrators first webinar for 2022 on enforcement of domestic arbitral award. On behalf of the management, I want to say a big thank you to our lead speaker for today, as well as our panelists for the roundtable section. I am actually so elated having my lords all online at this hour. I thought they were going to be joining us after the first section. So thank you so much, my lord, for the honor and privilege to have you start the webinar with us from the very beginning. This webinar has been put together by the Nigerian Institutional Arbitrators as part of benefits and continuous learning process, education for our members and non-members who are interested. We have noticed over time that enforcement of domestic arbitral award has been a source of concern and a major issue for a lot of arbitration practitioners. Because over time, we've seen the challenges that they have faced in trying to enforce the arbitral award, starting from the fact that some do not understand the process, the requirements, and the steps that are necessary to be able to get an award executed. So this morning we have the privilege of having our very own Mr. Agbola, FCArb, SAN, taking us on this. If you know Mr. Agbola very well, you will know that he is an expert in this field. He's one of the lawyers, legal practitioners that have been able to prosecute matters that has to do with enforcement of award or setting aside of award from the first court of first instance, even up to the Supreme Court. So definitely we're in very good hands this morning. I would like to, at this junction, welcome no other person than Mr. Adeleke Agbola, SAN, FCArb, to please proceed with his presentation. I know that definitely he will do justice to it. We are expecting a very practical and very lively and interactive section during the first section of the webinar for today. So over to you. I yield the floor to you, sir. Mr. Agbola.
Thank you, our able registrar. Like my Lord Justice Phillips, we know, almost every time I appear in court, the first thing I do is to correct the spelling of my name. I'm not Agbola. I'm Agbola. I'm Agbola. So thank you, Mr. To my lords on the panel.
I'm sorry, Theresa. I'll take notice of that.
It's okay. It's a privilege to be on the same panel with your lordships. My Lord Justice Phillips, we have known ourselves for quite some time. My Lord Justice Lawal, well, he has been on this same side with me before he crossed over to the other side. We have done arbitration together in the past. My Lord Justice Uzokwe is a privilege, sir. Not only on the bench, we are both chancellors in the Anglican Church. So I'm my Lord Justice Phillips, the Deputy Chancellor of my diocese. So,
I'm your junior. I'm your junior.
So we thank everybody for being here. And I thank the Institute for counting me worthy to present this lecture. I think this is the second time I'm happy to present this kind of lecture on the enforcement. It's an important aspect of the process, because when you get an award, you need to know what to do to enforce it. So I just go straight to the issue, and I don't know whether the secretary will be the one to be sharing the slide that is already with them, or I need to share from here.
I think it'd be nice if you share a slide so you can speak to it.
Okay. Well, it appears I'm trying to share. So it doesn't seem to be going through. I don't know whether you can see can you see my screen?
No, I've not seen it yet.
Okay. I think I may have to ask the assistance of the secretariat to share the slide for me. Host, Mr. Res, can you share the slide, please? Okay, thank you. So, well, I will just go straight to can you go to the second slide, please? Yes. Now, I'm sure all of us are familiar with the concept of arbitration, and it was defined in the case of Kano State Urban Arbitration Development Board as a reference of a dispute between not less than two parties for determination after hearing both sides in a judicial manner by a person or person other than a court of competent jurisdiction. The decision of the arbitrator or umpire is called the award. So once you start an arbitration process, you issue your notice of arbitration, you have gone through the hearing. At the end of it all, what is left is the award. The award can be something else. You can say, oh, go and do something, or just declare the right of the parties, just like a normal court judgment. The only difference is that it's the parties that have chosen their own judge. So from the definition in the FANS case, it is obvious that the end product of all arbitration is the award. It's usually the award. Because I say usually because sometimes arbitration is abandoned, either because the parties did not pay the arbitrator or something happened that terminated the arbitration. But if you go through the process and there's an award, whether you lose or you win, it stays the rights of the party. Slide 3, please. Arbitration in Nigeria is governed generally by the Arbitration and Conciliation Act. Some states, including Lagos State, have their individual arbitration laws, but in general, the laws are usually almost a exact replica of the FCA. Once an award has been made by an arbitrator, there is, as is common with any judicial process, a winner and a loser. In effect, the winner will press for the recognition and enforcement of the award, which the loser may apply for the setting aside of the award under Section 29 and or 30 of FCA, or for the FCA to recognize the award or its enforcement under Section 32 of FCA. As exemplified by the topic above for this seminar, our focus is on enforcement of domestic arbitral award in Nigeria. We say that focus because you can have international award, something, and you can have local matters. Where you have more because somebody can bring in an award from anywhere in the world and want to register in Nigeria. The topic of this seminar is not about those processes because it's a little bit different from the domestic award. Now, next slide, please. Now we have to discuss the applicable requirements as to the form of arbitral award. Now, Section 26 of the, please, you have jumped. I think you should be on the 4th. Yes, thank you. please go to, we are supposed to be on slide 4. Yes. Applicable requirement as to the form of arbitral awards. Section 26 of the Arbitration Acts make provisions for the forms and contents of an arbitral award. So for all of us, whether we are acting as an arbitrator or we are just, or we are parties to, we are representing parties in the arbitration process, we should know, we should all bring our mind to the provision of Section 26, which stipulate the mandatory requirements of what an award looks like. The first issue is that the award must be in writing. It looks so elementary, but it is important that that award must be in writing and it must be signed by the arbitrator or arbitrator, as the case may be. Where it is by a sole arbitrator, the sole arbitrator must sign. Where the application was done by a panel of 3 members, at least 2 members of the panel must sign the award. Where you have 3 members, you will not have unanimity about the award, but at least 2 people must agree out of the 3 people that forms the panel. And the requirement of writing is essential. In these days now, a lot of arbitration is done online. As we are doing this webinar, we have done arbitration, international arbitration. We have taken witnesses online, we're taking documents online. So a lot of times, even the award itself comes in online. But despite that fact, we must know that even when the award is sent to parties by electronic means, that award itself must be signed to make it valid. Because if it is not signed, it is a no-no. That award will be invalid. Then the second requirement is that the award must contain the place of arbitration. This is to ascertain the applicable law, which was used in determining the award. The place of arbitration is important because each time, and the first thing you determine when you set up an arbitration process is for the arbitrator and the parties to agree what is the place of arbitration. Doesn't mean we are the venue. That does not mean where you are sitting, where your parties are meeting, but to determine that this is whether if it's Lagos, if it's Kaduna, if it's Abuja, if it's London, you must take the place. You can have the place, the venue may be different, but parties, or if there is no agreement, then the arbitrator must rule on where the place of arbitration is, because that determines the law that will govern the enforcement process. The third requirement is that the award must contain, it must provide a reason for the award. The reason for the award must be stated. Unless the parties have agreed otherwise, you need to state the reason. It doesn't have to be as extensive as a judgment delivered by law, because sometimes the arbitrator may even be a lawyer, it can be an accountant, can be an architect, it can be anybody. But he must state how he arrived at his conclusion to determine whether it is a valid award or not. Then, a very crucial issue, next slide please. The date of the award must be stated on the face of the award. Next slide, please. The date of the award must be stated. The reason for this, why it is not just a mere form, is because for you, if you want to challenge an award, Section 29 of ACA provides just a window of 3 months from the date of the award or date of additional award for a person seeking to set aside an award to bring an application. So it is obvious, therefore, that in bringing an application to set aside under Section 29 of the Act, a party seeking this indulgence must act timeously. The question sometimes arises, though, as to when the date for calculating the date of the award should be reckoned from. Because sometimes an arbitrator gives an award. You will sit, if you are sitting as an arbitrator, and that may be the time, if you are not a very savvy arbitrator, to say, oh, there is amount outstanding. I'm going to give this award is ready, but until parties pay me the balance of my fees, I will not release the award. And if the man has already prepared it, sometimes parties may not pay up. It may take 3, 4, 5 months. If he has already dated that award, as at the time he indicated to the parties, oh, your award is ready, but there is an outstanding sum, I will not release the award until the date, until I get my balance. Then the question there arises, what date is the date of the award? This issue arose in the case of Adeleke, where the award was dated 15/9/1998, but was not communicated to the parties by the arbitrator until about 9 months later, in May 1999. Now, my lord that had the matter, I did that matter. It is because my lord would when he was about to release the award, he fell sick. Just Honorable Justice Olushola, the former Chief Judge of Lagos State. He fell sick and was out to be taken abroad. So it was only when he came back, Olushola Thomas, it was only when he came back, some months later, that he released the award. We were even just lucky because he released it and shortly thereafter he died. So the question then is, the application to set aside award was filed on 24/6/1999, which was about a month from the date of the communication of the award to parties, but about 9 months from the date of the award. The Supreme Court said this: the 3 months period stipulated in Section 29 of the Arbitration and Conciliation Act for filing the application to set aside the award started to run from the date the award was published. So where there is a dispute as to when if parties agree that the award was not communicated to them until so date, is the date it was communicated that it is important. But nonetheless, it is extremely important that a date be put on the face of the award itself. Now, I want to say that it is only Section 29 that stipulates the period for you to the 3 months limitation. Next slide, please. It's the only Section 29 of FCA that stipulates that you must bring the application to set aside within 3 months. Next slide, please. Section 30 and 32 of FCA, which deals with setting aside an award due to misconduct. Next slide, please. Which deals with misconduct of the arbitrator or appeal to refuse recognition or enforcement, respectfully do not appear to stipulate a time limit. However, as stipulated by the Supreme Court, when considering analogous provision in the arbitration laws of Nigeria, in Kano State of Land Development Board and Funds Construction, it states, in application to set to court for extension of time within which to have the award set aside, all relevant matters will be considered, like whether it has already been sought to have the award enforced. I do not think, however, it is a true proposition of law to say that it's too late to seek to set aside an award after it was sought to be enforced. The better view appears to me to be that once an award has been enforced, or as opposed to an application for it to be enforced, it is too late to have the award set aside under Section 12 of the law. For those seeking to set aside an award under any of the sections of the law, therefore, they should always remember the Latin maxim, vigilantibus et non dominantibus jus subvenient. The law will aid those who are watchful and those who do not go to sleep. So once an award is given against your client and you want to challenge it, it is important that you take immediate step, because the man who wants to enforce it may quickly rush to court and say, I want to enforce. If you want to set it aside, you too must be vigilant so that it will not be too late. Now, publication and delivery of award. It is important to state the arbitral award is not a public document. In fact, one of the attractions, next slide, please. It is important to state the arbitral award is not a public document. In fact, one of the attractions of arbitration. Next slide, please. Thank you. Next slide. It is important to say that arbitral award is not a public document. In fact, one of the attractions of arbitration is its confidential nature. However, an award may be made public with the consent of the parties. It is a mandatory feature of arbitration that a copy of the award should be sent to each of the parties. However, in considering this position, it has been argued that no time limit should be imposed as to when this must be done. Generally, when the award is ready, the arbitrators write the parties simultaneously informing them that the award is ready for collection. An award is deemed published when the arbitral tribunal gives notice to the parties that the award is ready. For those of us who are acting as arbitrators, it is important that the notice must be given simultaneously. If you inform party A on Monday that the award is ready, and you choose to inform party B only on Friday, that may amount to misconduct. I've seen a case in England where an award was set aside for just that very reason, because you must treat both parties equally. So it is not enough, because there is no point disclosing in advance to one party that an award is ready and you do not tell the other. Sometimes this is important because sometimes maybe only one party that paid your fees, and that is why you should be extra careful. Whether it's one party that paid your fees or both of them paid, you must treat them equally in as much as your fees is paid. Once your fee is not paid, it affects both parties. So it is important. Next slide, please. An award must be complete. An award is said to be a complete award if it contains adjudication of all the issues submitted to the arbitrator for determination. In fact, it has been argued that the duty of the tribunal is to make a complete and final resolution of their issues by its award, and that it's a breach of that duty to leave any part of the decision to be determined subsequently or by another arbitral process. This does not preclude the arbitral tribunal from making interim awards in the course of the year. When we say that award must be complete, that does not mean everything must be contained in just one single document, because there may be urgency in certain situations that we allow for interim awards if both parties, if application is made to that effect, that, okay, so you can have an interim award before you have the complete award. But whatever you do, even the interim award must be conclusive as to the issues determined by it, so that you don't have to come back about it. If you make an award that is subject to further steps being taken, then you have not made a full you have not made a full and complete award. Next slide, please. The award must be certain. This basically means that the award must clearly state what parties and what duties and obligations are imposed on any of the parties. For instance, where the arbitral tribunal directs in the award that money must be paid, it must state the amount payable, to whom, and by whom it is to be paid. Where the award is uncertain or inconsistent, the court will not enforce it. But where the valid part is variable from the invalid one, the court will enforce the award, will enforce the valid part and set aside the uncertain part. For example, where the arbitrator awards interest on a principal sum, where interest is not allowed by law or custom of the business, the court may set aside the interest element of the award and affirm the award for the principal sum. So that is why it is incumbent on us when we are acting as arbitrators to ensure that we specify in very minute detail the enforceable, the operative part of the award, so that you know exactly what Mr. A is to pay to Mr. B. And it is always better if you award interest for it to be a separate element, so that if for any reason it is found not to be payable, it can easily be severed from the award. It can be very, very painful and costly to the parties if an award has to be returned for fresh hearing or for the arbitrator to make some definite award because of his own errors. Now we go, so those are the things that must be stated on the award, because the award itself must be valid before you can enforce it. Now, the next issue is, what are the provisions governing modification, clarification, or correction of an award? Now, a party within 30 days of receipt of an award and with notice of the other party requests the tribunal to correct in the award any errors in computation, any clerical or typographical errors, or any error of a similar nature, and giving an interpretation of a safe point or part of the award. We have said before that our award must be clear on its face, it must be certain, but sometimes due to clerical errors, certain things are not so clear. It is the duty of a party who has received the award to study it quickly to see whether there is any error that needs to be corrected. Sometimes the arbiter himself, after releasing the award, may see that certain things have not been done in the award. We have to notify the parties and make corrections. When that application is made for correction, the tribunal shall effect the correction within 30 days. The tribunal may also, on its own volition, within 30 days of the date of the award, correct any error. A party can also request the tribunal to make an additional award as to the claims presented in the arbitration, but omitted from the award. An additional award shall be made within 60 days of the request. So sometimes you get an award, you ask for 5 release. The arbiters say, oh, you are entitled to all your release, but in the operative part of the award, it will only stipulate 3. It will only grant you 3 of what you have requested for. So if that is an error that it doesn't flow from the reasoning that he has given in the award, you can ask for correction and say, please. Of course, it's for the arbiter to see whether that is an error he made or consciously he didn't award it to you. You can, whatever the reason, you must state it and respond to it within 60 days. So, and we have, you can see the operative provision in section 28 of the Arbitration and Conciliation Act. So, we will not have bothered to read that one because it's in the law. So you can just check that one out. Now, after you have gotten your award, you have done all the corrections that you have gotten an award now that is ready for enforcement. This is now for you, the decision now, if you're on the winning side, you want to enforce. Of course, if you're on the losing side, you may just take it. But in Nigeria, almost every award is challenged. We don't have that spirit in us to accept the decision of arbitrator. We are still praying for it as final. But if you are on the winning side, what do you do? And that is the main thrust of this seminar. What do you do? How do you enforce? Now, the applicable procedural law for the recognition and enforcement of a domestic arbitral award is the Arbitration and Conciliation Act 2004. Section 51 provides that an arbitral award shall, irrespective of the country which is made, be recognized as binding and subject to this section 32 of this act, shall, upon applicant right to the court, be enforced by the court. The party relying on award or applying for its enforcement shall supply A, the duly authenticated original award or a duly certified copy thereof. B, the original arbitration agreement or a duly certified copy thereof. And C, where the award or arbitration agreement is not made in English language, a duly certified translation thereof into the English language. In Lagos State, which has its own arbitration law, section 2 of the Lagos State law said that all arbitration within Lagos State, unless expressly excluded, shall be governed by it. Section 56 is similar to it's also similar to the section 51 of ACA. Now, so when the court, the next thing for you as somebody who is acting for a successful party or somebody who is challenging an award is that you have to determine which court has the jurisdiction to hear you want to bring the application for. Now, the courts that have jurisdiction over application for enforcement of arbitral awards are the Federal High Courts and the High Courts of the states. Section 29 and 30 of the Arbitration and Conciliation Act provides that a party who is aggrieved by arbitral awards may, within 3 months from the date of the award, or in a case failing within section 20 of this act, from the date of the request for additional award is disposed by the arbitral tribunal. by way of application for setting aside, request the court to set aside the award in accordance with section 2 of this section. The court may set aside an arbitral award if the party making the application furnish proof that the award contains decisions on matters which are beyond the scope of submission to arbitration. So, however, that if the decision on those matters submitted to arbitration can be separated from those not submitted, only that part of the award will contain decisions on matters not submitted may be set aside. The court, before which action is brought under section 1 of this section, may, at the request of a party, where appropriate, suspend proceeding for such period as may determine to afford the arbitral tribunal an opportunity to resume the arbitral proceedings or take such other actions to eliminate the grounds for setting aside of the award. Where an arbitrator has misconducted himself or where the arbitral proceeding or award has been properly procured, the court may, on application of a party, set aside the award. An arbitrator who has misconducted himself may, on the application of any party, be removed by the court. Now, you can go to court, but which court? Because the law has said federal high court or state high court. Section 57 of the ACA defines courts to mean the high court of a state, the high court of a federal capital territory, Abuja, or the federal high court. It defines a judge to mean a judge of the high court of a state, the high court of the federal capital territory, Abuja, or the federal high court. Now, in Agbola and Sani, the court held that the Lagos State High Court has jurisdiction to appoint an arbitrator in respect of the sharing formula of shares in an incorporated company, despite the fact that the court that is vested with exclusive jurisdiction in respect of companies and online matters is the federal court. The court went further to hold that the quarrel was between the two partners, intersect, and does not enforce the jurisdiction of federal high court. Compare, however, this decision with the decision of the court in Cabo Air Limited and the whole corporation, where it was suggested that a foreign judgment arising from the High Court of Gambia in response to an arbitration dispute is registrable at the federal high court, because also the transaction that led to the foreign judgments in the litigation at the High Court of Justice of the Gambia involve an aircraft which is within the exclusive jurisdiction of the federal of the court below. Now, this is usually one of the most contentious issues, the issue of which court. If you're a seasoned arbitrator or arbitrator attorney, it is, if you, I did a matter in Enugu, we did in Anambra State. We filed an application before the state high court. It's in respect of a federal government institution. After the award, we tried to register it at the Anambra State High Court. The lawyer for the university challenged it that they are a federal institution, that the court does not have jurisdiction over them. We argued the then CJ of the Anambra High Court rejected our application and struck out the matter. So we have to file again at the federal high court that to enforce the award. And the federal high court also, the federal court, the same lawyer who argued at the Anambra State High Court that federal court is one in jurisdiction now filed another penal objection at the federal court, challenging the jurisdiction of the federal court that the subject matter, it relates to a private contract between two parties. So it has nothing to do with federal high court. And in fact, that matter was not resolved until you get to the Court of Appeal. And eventually the matter was registered. So it's part of the games of lawyers that this issue of jurisdiction. So my advice is that to avoid unnecessary waste of time that may be caused by frivolous plenary objection, it is recommended that applications for recognition and enforcement of arbitral awards should be brought in the court that has subject matter jurisdiction in the matters leading to the award. Because this is one of the reasons why enforcement takes years. Because what we are taught is that arbitration is supposed to be fast, and so that instead of spending years in court, you can get it done within we have done arbitration within 2 days, with involving billions of naira. Yet we spend years trying to get it enforced. That is the problem. Now, challenges faced in enforcement of domestic arbitral award. As we just raised, the issue of jurisdiction is one of the challenges encountered in enforcement of domestic arbitral awards. And that is the issue of which is the proper court to approach when enforcing an arbitral award. Because the truth is that we have this problem all the time. And even those who are very knowledgeable in this matter will still fall into the trap, because we file in one court, you think everything is settled, and the other party will bring a penal objection. So issue may arise as to whether the subject matter of the arbitral award sought to be enforced is a matter within the jurisdiction of federal court or the state high courts. Oftentimes, parties who are not successful at the arbitration will use every possible means to frustrate the enforcement of the arbitral award, so they resort to raising the issue of jurisdictions to stall the enforcement process. As we have advised above, it is better to err on the side of caution and bring the action at the court with the subject matter jurisdiction. Even that one is not so simple, because sometimes you know which is the subject matter. It can be because there we have decisions saying any matter involving via a federal government institution is a party, must go to the federal high court. Those are the Agbola line of cases. But you also have matters saying, oh, no, it's not enough. You must, if the subject matter falls within the state, you must go to the state. We hope one day we have resolution of these matters. Now, the second issue, apart from your jurisdiction, is the long period of time involved to have an award enforced or recognized. Another challenge faced by parties is the amount of time it takes to have a domestic arbitral award enforced and recognized. We have a limited number of specialized judges in the field of arbitration in this country. At this juncture, I must thank my Lord Justice Phillips. When he was the chief judge, most of the arbitration matters usually come before her, and I know she doesn't listen to all these stories. Within maximum of 2 years, you are out. You know where you stand. My Lord, I thank you.
Thank you.
We have a limited number of specialized judges in the field of arbitration in the country. Arbitration is a very peculiar judicial system of adjudication. And if the enforcement of the award is not handled by competent and specialized judges, it may lead to erroneous decisions by some courts. And the handling out of judgments is perceived to be an intrusion on the finalities of awards issued in arbitrations. Also, parties tend to apply for awards to be set aside without a proper legal basis as a delaying tactic. The unwillingness to accept the result of arbitral process is also due to the failure of many litigants and their lawyers to accept the result of a process voluntarily enter into. For example, the notice of arbitration in the case of Okeke and United was issued on 16/12/1996, and the matter was finally disposed of by the Supreme Court on the 27th of January 2017. That is a period of more than 20 years. We spent millions, and yet 20 years to resolve our arbitral dispute. Where is the finality? Where is the cost effectiveness? Where is the speed? We trumpet so much most of the time. It is ridiculous that a commercial dispute resolved through arbitration should take such a long time. We hope that in the ongoing process for constitutional amendment, the right to challenge an arbitral award should have its terminal point at the Court of Appeal. And even in that case, costs for successful appeal should take into cognizance the actual costs incurred by parties, including solicitors' costs. I think this cannot be overemphasized. Number one, some judges, when matters come before them in arbitration, they take it as if you are arguing an appeal. They start going into the process, the documents that was accepted by the arbitrator, the one that was not accepted. Whereas that is not, it's not supposed to be an appeal. It should be a matter that on the face of the award, is there a misconduct established? They will not go into the issue as if, and then you have to litigate the whole thing all the way again. And then the issue is that even when the party which challenged the award ultimately fails, the issue is that it will have won, because if there is a judgment in Naira for you, even 5 years ago for 100 million, and it takes 5 years, and it's not being resolved, the value of the Naira is gone. The 100 million Naira is hardly worth up to 10 million Naira as at the time you have the award. So the issue of cost, how can we do a matter from arbitration to High Court to Court of Appeal to Supreme Court, and the Supreme Court will award only cost of 100,000? I just finished a matter with London State. The cost awarded in that matter, that took less than 1 year to resolve, is 12 million pounds. So you have to think seriously whether you want to challenge it, to see whether you should go to arbitration. So if costs are commensurate, God help you if your seat is London and you have a rubbish matter and you didn't settle it before going to arbitration, you will be damnified heavily in cost. And that is one of the reasons why their system is fast. I don't know, my laws that are still sitting, my Lord Justice Lawal, lawyers will complain, but it is the high time that lawyers knows that if they mess up, if they come to a court with an incompetent application or matter that has no chance of success, they know that they have to pay a recovery cost. If not that, even if the man does not make a profit, you know what it costs to bring the lawyer to court. Now, another issue that comes to court, I think at 2 years ago when we were doing the meeting of NICAP, I remember some people say, oh, we should expand arbitration into criminal matters. We should expand arbitration into family land disputes. There are so many things they were asking. So the issue is whether those issues are actually arbitrable. So the next issue really is capability of settlement of the subject matter in dispute by arbitration. Is this something that arbitration can actually resolve? One of the issues in the enforcement of arbitral awards in Nigeria is the capability of settlement of the subject matter in dispute by arbitration and the public policy. Section 48B of ACA provides that the court may settle an award if it finds that the subject matter of this dispute is not capable of settlement by arbitration under the laws of Nigeria, or the award is against the public policy of Nigeria. Thus, arbitration has been uttered on the ground that the dispute could not be settled by arbitration under Nigerian law or was against the public policy of Nigeria. So this one really is important when you are talking about international arbitration, because you can obtain a judgment abroad. We have so many judgments against Nigeria now that I don't know how we are going to survive if all those judgments come to rest. Billions of dollars, either because of incompetence or because of, there was the notorious one that allegations were made against a respected senior advocate that he compromised Nigerian interests. So the issue really is that even when there's an award, you have to be sure that it is not against public policy. Because if we go to bring down the government of Nigeria or make it impossible to go out to rule, I don't know whether you can really enforce that award in Nigeria, because we are seeing situation where judgment nowadays people are borrowing money, they are using public properties to borrow money. Sometimes even court biddings and government offices are being used to borrow money. I wonder if somebody obtained judgments against Nigeria using on those bases against our airport, and they want to enforce it in Nigeria, whether our courts will be willing to accept those ones. We are waiting. It's going to be an interesting period ahead, because the rate at which money are being borrowed and the property that are being used as collateral for those loans, I wonder whether the courts will be able to say, oh, go and sell those buildings just because it is contained in the commercial agreement. Now, next slide. Limitation period for commencement of enforcement proceedings. I think I have another 10 minutes. I will soon be over. Another issue is the limitation period for commencement of enforcement proceedings. Section 81D of the limitation law of Nigeria of Lagos State, with similar provisions in limitation laws of other states of the Federation, provides that every application to enforce an arbitral award must be brought within 6 years from the date the cause of action accrued. The question that arises is when will the 6-year period start to run? You see, from the date of the accrual of the original cause of action or from the date of the arbitral award. The implication is that a party cannot successfully bring an action for the enforcement of an arbitral award outside the statutory 6 years limit. So it's expected for you to install the Scott and Avery clause so that you can postpone time for running until when the arbitral award is made, because the issue is not so clear in the limitation law. And another issue, which I think I've raised before, is the length of time it takes for arbitration cases to reach the Supreme Court. Arbitration cases take between 6 to 12 years to get to the Supreme Court, not from even the high courts, not from where the award is made, from the time, even from the Court of Appeal to the Supreme Court. Because even when you have a judgment in the Court of Appeal, it may take you another 10 years. In fact, standard now is 10 years before you can start agitating for you to be listed. So it takes up to 6 to 12 years to get to the Supreme Court before a final decision is issued in favor of enforcement of the award, by which time the rest may have been destroyed. Now, what are the steps that a counsel should undertake in enforcing domestic arbitral award? Section 51 of the arbitration of FCArb provides a unified legal framework for recognition and enforcement of both local and foreign arbitral award. Now, an arbitral award shall, irrespective of the country which is made, be recognized as binding and subject to section 32 of this Act, shall, upon application right to the court, be enforced by the court. And we have what we need to supply. In the case of Imani and Sons Limited and B Construction Company, the Court of Appeal held that in addition to the motion notice by the party seeking enforcement, the party also needs to provide the following simple requirements: the arbitration agreement, the original award, the name and last place of business of the persons against whom it is there to be enforced, statement that the award has not been complied with or complied with only in part. In Ebokama Iprenibe, the Nigerian Court of Appeal listed additional requirements needed for a party seeking recognition and enforcement under the New York Convention. The requirement as follows: the arbitration agreement, that the dispute arose within the terms of the submission, that the arbitrators were appointed in accordance with the clause which contains the submission, and the making of the award, and that the amount awarded has not been paid. Once the court recognizes the award by granting leave to the creditor to register his same, it shall be enforced as a judgment of the court. It is important that Section 31 of ACA, which provide the method for enforcing a judgment, has not specified whether the other party should be put on notice. However, with the decision reached by the Court of Appeal in Allied Energy and Nigeria RGB Explorations Limited, it has become expedient for a successful party seeking to register and enforce an award to put the other party on notice. What we are saying that when you look at the rules, it didn't say, oh, you must put the other party on notice. It just says you can apply. But the court have interpreted that section to mean it's not fair to try to register an award without letting the other party know that you are trying to do so. So those are the steps that the practitioners must take. Now, the impression created by many is that Nigeria is not an arbitration-friendly environment, but a dispassionate review of the cases that goes to the Superior Court will reveal that most arbitral awards are upheld by our courts. Indeed, as stated by Kekere GSC in 19 to underscore the fact that the court does not sit on appeal of arbitral award, it is to be noted that even where the court finds merits in application to set aside an award, the decision is limited to setting aside the award and remit to the arbitrator for reconsideration. The court has no jurisdiction to determine the merits of the matter, which is the subject of arbitration proceedings.
Yeah.
Now, that is important because I've seen so many others that we just dismiss it. Most judges do not include the order to say, go back to the arbitration. And then, because that means the issue of time, of whether the matter is still too bad or not to come in. I think our judges should be encouraged to not just dismiss where there is any error, any misconduct found to have been made by the arbitrator. They should return it back to the same arbitrator or perhaps another one, so that the errors can be corrected, so that it is still an issue for the arbitration, not a matter for the judges to determine. Another issue that sometimes arises that, oh, you may have a name, an issue of name, the name of the parties. Recently, we are familiar with Petroleum Industry Act. There are a lot of cases against NNPC, which are still going through the court system. A lot of parties have not amended the names. And I'm sure very soon we'll be hearing people challenging that award is made against a party that does not exist. But look at what the Court of Appeal stated in Okeke and Nnamdi.
It's gone off.
Okay. Let's just give him a few seconds. I'm sure he's going to get back on.
Oh, okay. I thought it was just me.
No, ma. Oh, I think it's network.
Okay.
Let me just chat him so he knows.
Okay.
Okay, it's all finally.
Hello.
I can't hear it.
Okay. I think I'm back now. Sorry about that.
That's all right.
Okay. So what we are saying is that even when there are misnomer in describing a party on the face of the award, if that award is identifiable, if that party is identifiable and has participated, especially in the proceedings before, the court do have the correct to make the correct of that name. So, but the important thing to note is that majority, I don't know whether it was our president, Professor, what's his name again? I remember there was one time there was an effort was made to check out the percentages of matters that goes to arbitration and the enforcement process. And about 94% of them are found. So I think arbitration is doing well in Nigeria. It's only the speed in which matters are resolved that is causing problem. So from the practical viewpoint, enforcement of arbitral award in Nigeria is on paper a seamless exercise if a lawyer follows diligently the procedure as stipulated in the ACA or any other state law that may be applicable. In our opinion, the delay witnessed in enforcing arbitral award is due more to the systemic congestion in our court system than due to inherent failure in the enabling status. Also, it is high time our judges follow the details of the law and not treat application for recognition and enforcement award as if they are sitting as a court of appeal over the arbitral tribunals, as this will enable them to expeditiously determine any challenge and award in accordance with the limited grounds stipulated in the law. So thank you. That is just remember when you are applying motion on notice, make sure you comply with all the laws and attach all the requisite documents. Surely it should be okay because once you have gone, the application has given an award in accordance with the law. So I thank you, everybody, for listening.
Thank you, ladies. Thank you so much for this. I'm sure that we are all have learned on how to enforce arbitral awards in the Nigerian courts. There's some questions for you, but because of time, we will take the questions at the end of the panel section. We are supposed to go on a 10-minute break, but I feel that we should just continue with the conversations so that we are able to keep to our scheduled time. I know we're all very busy personalities here. I'm going to, at this junction, invite our very own Hilda. Hilda is the coordinator for River State chapter of the Institute to take over as the moderator of the section, the roundtable section on challenges and pitfalls in the enforcement of the domestic award. We'd like to hear from the judge, when Mr. Agbola was talking about enforcement, we could see the role that the courts play in why we have a lot of delay, as well as the legal practitioners. I would like that as judges, my Lord Emeritus, that has been in the forefront of the judiciary in Nigeria, particularly Lagos State, the foremost state in judiciary in Nigeria. I'd like that you please look at it from the judge's perspective. What can the lawyers do? What can we do to ensure that a lot of all these bottlenecks that are created, we're able to overcome them? And also some suggestions for us as an institute, how we can go about trying to also intervene and smoothen the process. So I'm going to turn over this section to our very own Hilda Desmond Ikari, FCArb, to please proceed with the roundtable section of the webinar. While we're waiting for Hilda, let us see, there's some questions for you. Please just go to the chat, go to the chat room and the question and answer section.
Okay.
I will do so.
Good morning. Oh, yes, good morning. Please, may I, with respect and humility, call on the persons who are going to take the roundtable sections of this webinar. Honorable Justice Ayotunde Phillips, Fellow, Nigerian Institute of Chartered Arbitrators. You're very welcome, Lord. May I also call on Honorable Justice Theresa Uzokwe, retired, fellow Nigerians. Welcome, Lord, to the roundtable session. It's our pleasure having you.
Thank you.
May I also, with your leave, call Honorable Justice Lawal, fellow Nigerian Institute of Chartered Arbitrations. These are well-seasoned, both sitting and justices, and people that are versed in arbitration that are going to take us on this. Yes.
Thank you.
The floor is open for us.
Thank you.
May I just intervene at this point to say that, my lords, with due respect, we're sorry about the mix-up. Honorable Justice Ayotunde Phillips is former Chief Justice of Lagos State, Emeritus, retired. Honorable Justice Uzokwe is the former Chief Justice of Abia State, if I'm correct, Emeritus, retired. So I'd like to accord to them the honor that is due to them. So welcome, my Lord Justices, to this section. Hilda, could you please check your network or the microphone you are using? You're not coming out very clear, so that we can have a very good section. Well, while Hilda is trying to put
together. Thank you. I apologize.
All right, go ahead. I have officially made myself a standby moderator in case Hilda runs into it. So please allow me. So Hilda, go ahead. I'm standing in for you. So if you have any issues, I will take over from where you stop.
Okay, no problems. I apologize for not calling the offices of the Lord, the Chief Justices. I apologize for that. So the roundtable discussion is open. I humbly call them to start up the discussion.
Now, who goes first?
Honorable Justice Ayotunde Phillips, retired, former Chief Judge of Lagos State. Sir.
All right, thank you
Now
very
you
much.
have the floor.
Thank you very much, Hilda. Thank you very much, Shola. My Lord, good morning. Good morning for where I am. I think it's already afternoon there in Nigeria. Mr. Agbola, I didn't know you'd become a silk. Hearty congratulations.
Thank you, my Lord.
I'll send you a personal message. Hearty congratulations. I'm very happy for you, and I wish you all the very best and a very, very fruitful and prosperous tenure in the inner bar.
Amen, man. Thank you, man.
Mr. Lawal, well, he's one of us. How are you, Justice Lawal?
Good morning and thank you, my Lord. I'm fine, my Lord.
We look forward to hearing from you. Well,
it's a pleasure meeting you, my Lord.
Thank you. Well, fortunately for me, I have been a sitting judge and now I'm a retired judge. In fact, the other day, it dawned on me that this is the 8th year of my retirement. The time has gone by so fast. We thank God. And so I've experienced sitting as a judge, like Mr. Agbola mentioned, over arbitral matters when they come for setting aside. And now I'm an arbitrator. I now act as an arbitrator. So I've seen both sides of the coin. And to be honest, it was very disappointing because I thought arbitration was the way forward to speed up the justice delivery process. And it's turned out to be very, very slow. It's even slower now that I'm an arbitrator. And Mr. Agbola has pointed out very succinctly all the pitfalls that members of the bar put in our way during arbitral proceedings. Now, the whole idea of arbitration, as we were made to understand it in the High Court, was it should be much faster than the day-to-day court matters. So people should run there. You pay a bit of money, it's not cheap, but for your high fees, you will get speedy dispensation of justice. But it turned out not to be so because the same antics that lawyers bring in court to delay matters in court, they're doing the same thing in arbitration. And I must be very honest, that is what I have seen. I've handled several since I've retired, and I'm not happy about what is happening at all. So first of all, you cannot have an arbitration, as Mr. Agbola has pointed out, without having an arbitration clause in the agreement. No matter what the issue is, once there's an arbitration clause in the agreement, you must go to arbitration. Whether it's family law, somebody is asking a question about, I thought it's only commercial matters. It's in whatever agreement you have, 2 parties have, or 3 parties have. So far as there's an arbitration agreement, you must go to arbitration. So that's out the jurisdiction of the courts. And many matters have been struck out because of this, where the first thing the lawyer does is after getting the arbitration award and it's awarded against his client, he runs to court to set it aside. Meanwhile, the other lawyer who has the arbitration in his favor, award in his favor, runs to court to enforce it. Because you can't enforce it on its own. You need the court machinery under the Sheriffs and Civil Process Act, judgment enforcement rules to enforce the award. So there, the court is now faced with 2 applications, which are usually consolidated and taken together, and a ruling or decision is made, and the court either agrees to enforce it, makes an order for enforcement, or agrees to set it aside. And you can only set aside, as Mr. Agbola has correctly pointed out, where there's misconduct on the part of the arbitrator, or where the arbitrator clearly has not handled it properly. It is not for the court to go into the merits or demerits of the arbitration. You're not sitting an appeal. A court is not sitting an appeal over an arbitral award. It is just seeing that it has been done within the ambit of the rules and the law guiding it. Having said that, that's the beginning of the delay. Some matters to set aside and enforce can be in the high courts, be it the federal high courts or the Lagos State High Court or any state high court, because of the congestion in all the courts. More so now that COVID has come and courts were destroyed and courts could not sit for about a year, and then there were the JUSON strikes and all kinds of things, and there was NSAS. So I mean, I shudder to imagine the backlog in the courts now. It could be there for years, 2, 3, 4 years. I wasn't surprised when Mr. Agbola said that to go from appeals from the Court of Appeal to the Supreme Court now take between 6 to 12 years. I mean, like, where are we headed? And yes, these are all arbitration, mediation, conciliation. These are all issues or bodies or parts of law that can, justice delivery system, that can make it much faster for everybody. But we're not using them as we should use them. And that is my frustration as a sitting arbitrator now. It's not fast. I've got an arbitration that's been pending before me now for about 4 years. Each time we try to bring it up, the defendant comes up with something. He's sick, he's in London, he's receiving treatment. Then we delay it for him to come back. Then he won't pay. The other party has finally agreed to pay. And you know, it's the whole thing is a mess. Sorry to say. So from my personal experience, we need to really sit down as judicial officers, both retired, serving, and the lawyers, and agree to have a situation whereby we're going to speed up the process. There's no point having an arbitration and for years you cannot conclude it. And when you do have the one or two that you can conclude, they're stuck in the machinery of the courts where the unsuccessful party is trying to set it aside. He would probably tell his client, don't worry, we'll just lock them up in litigation for the next 12 years. By that time, the claimant would have died. And that would be that. So you don't get the fruits of your judgment. And that is, you know, that is my personal experience, because I believe we're here really to talk about, Mr. Agbola has done the academic bit. It's for us to say what we see as serving arbitrators. When I was in the High Court, as at the time I was about to retire, because I was the chief judge between 2012 and 2014. And I thought to myself that, what do I do when I retire? Oh, I can still do arbitration because this is all I know. I don't know how to sell lists. I don't know how to cook food for sale. I don't know how to sell gold. And I must keep myself busy. I said, I'll go into arbitration. So I introduced it to all the judges that, look, all of you, no matter how young you are, we too were young when we started. 20 plus years has gone by now, and we're about to retire. It's going to happen to you. Start preparing for your retirement now. So we now started getting involved in arbitration. And then we began to understand, because personally, I thought arbitration was a nuisance at first. I knew nothing about it. Till I now realized that, well, this is a faster way of doing things. And that's where the multi-door courthouse came into being. So I introduced this to the judges. We started to do the exams. We did the membership of the UK Institute of Chartered Accountants, Chartered Arbitrators. We did the exam. I was introducing it. So we now could understand what it was for. Then we realized that many of the senior advocates were very much involved. In fact, they had cornered the whole of the arbitrations. Mr. Agbola.
My lord, I've been arbitrator before I ever became senior advocate.
It doesn't matter, you are enjoying the upper echelon now. They cornered the whole market. But we still managed to, luckily, if they like you, they will involve you more or less, they'll involve more in what is going on. So I now saw that this is a very, very good thing, only for me to now be part of it, and I see how slow it can be. Some go well, but then and then they don't want to pay fees. I have been one now for the past 4 years. They have refused to pay us fees. One excuse, I even got a letter yesterday, one excuse after the other. So these are the frustrations, my personal frustrations with the whole system. So maybe the younger ones can tell us how best to go about this. Because, this is the only way forward for the judicial system, especially now with COVID, that everybody is now doing Zoom. Well, if not for COVID, we won't be having these Zoom meetings and Zoom webinars, Zoom discussions. Thank God for that. I mean, COVID was nasty, but at least it made us start thinking outside the box. And we've got to now apply that. Because in England, they don't joke with arbitration. When the man gives you an award, they don't go to court to set it aside, or maybe just to enforce. And like Mr. Agbola said, when the award costs against you outside Nigeria, it's a terrible thing. I mean, they probably sell everything you have, lock, stock, and barrel, just to pay the lawyer's costs. Not to talk of the arbitrator's costs and their fees. So I'll leave it there so you won't appear as if I'm taking over everything, but this is my personal experience about arbitration. I'm very disappointed. We need to do something about it. If we're going to have the Chartered Institute should have round tables, invite some of us, and let's sit down and let's see what we can do about this, because we can't continue to allow this situation to continue in this very, very unpalatable situation. We cannot continue like this. We've got to sit up and do something about it. There's no point complaining without finding a solution. We must find a solution. And there must be a way of reaching out to lawyers in particular, that this is not for you, it's for you. Charge your client your fees and tell him the truth and let's get on with it. The courts are inundated, the courts are congested, the whole place is in a mess. We have an opportunity now this is an opportunity for all the arbitrators to make good money for themselves. When they see that the thing is moving in the alternative, the dispute resolution sector, people will rush there to have their matters taken care of. Family matters, land matters, maybe not, but commercial matters, definitely. Time is money for them. So why should we delay? So we're still having delays, and it's still very upsetting to people like myself. Thank you very much indeed. Over to you, Hilda.
Where is our deputy moderator?
Chola, where is she?
Are you sure you can get it?
I think my Lord Justice Uzokwe is next, so that we can win on this.
The presenter of this paper, before I go to his conclusion, let me thank him very much for a well-researched paper. Well-researched paper.
You have the floor, madam.
Thank you.
Yeah. I thank you very much for a well-researched paper.
Thank you.
And then before I go to his conclusion was some of the judges feel that they are sitting on appeal over the case brought before, arbitral matter brought before them. I don't think so. I believe that the courts themselves are having difficulties in getting on with some of these matters. Let me stop there to go back to the beginning of arbitration. What really causes the delay? I believe that the delay in everything, I'm sorry to say because I'm an arbitrator myself, is caused by some arbitrators or most arbitrators. We all know the rules. We all know the ethics. What do we do with the ethics? Most of these things are set aside because the arbitrator, compromised himself or corrupted himself. Why should an arbitrator do that? If he didn't do that, so that means smooth sailing. Everything will be done, award given, and then the losing party will not run to say he misconducted himself. He wouldn't do that. But this happens every day. You see some arbitrators fraternizing with the other one party or the other, which I believe is very wrong. And another arbitrator, member of that panel, they're not correcting. These things should not be allowed to continue. They're not correcting. And then the delay. Also, everything the court has to sort out. For instance, there's this judgment, this beautiful judgment written by Justice Oshodi of the Lagos High Court. I've always admired their arbitral, everything about the Lagos High Court. I must say it is much better than I've seen around me or some other states. He had this judgment to write. The case was brought before him. You could see he was struggling to finish that matter. At the end of the day, one of the objections of the losing party was that there was only one arbitrator. Isn't the law clear? The law is clear that in the agreement, if there's nothing said in the agreement about the number of parties, arbitrators rather, that 3 arbitrators should be appointed, but only one was appointed. And this man felt that he would leave it at the last moment to make his objection, and he did. But just socially had no option but to set aside the award, because the law is very clear. If there's nothing in the agreement as to the number of parties of arbitrators, arbitrators must be 3. Make them 3 arbitrators. Only one came forward, and there was a lot of issues with that particular one, bias, this and that. So he set aside the. Can it now be said that he didn't want to do what he ought to do? He should have just given the award. It will still go on appeal to the Court of Appeal, from Court of Appeal to Supreme Court. And I keep wondering, why at this stage we should allow these things to go to the Supreme Court? These people who go to arbitration, the impression they have is that we are just going there to finish up because of the congestion in the courts. We cannot understand the delay in the court. A case lasts 7 years, 8 years, 10 years. But look at the case, the Nitel and Okeke, the presenter just mentioned, lasted 20 years. It was supposed to be arbitration. What kind of arbitration? If other members of the public hear that, they wouldn't want to go to arbitration. And then, I don't know why some arbitrators will not even look at what they're doing, or rather, be more diligent. The case is presented before you. Before you quickly write the award, look at what is presented before you. If what is presented before you, submission supports it, why do you have to give just a part, can I call it part award, and leave the other one when the submissions were clearly there? Now, the losing party goes to the Court of Appeal, or they get even up to the Supreme Court. He's objecting. The whole award was not given. And what happens? If this has to be returned to the arbitrator, the arbitral panel or tribunal, unless immediately the tribunal notices that, the tribunal may go on to correct little things like typographical errors, errors in interpretation and all that. A tribunal is sitting. Why don't they carefully look at these things, correct all the errors before they make the award? And why should a tribunal write an award, keep it back, or send, or publish the award to only one party? Why? Doesn't it show bias? Even if the other party has not paid you, I'm sure there's not be a way to recover their money. Instead of keeping all of them. How can you write an award and keep it for 8 months? Then when the losing party gets the award, then what does he do? He now has an issue with all the delay. Then it takes him about 1 month to protest. He now protests. At the end of the day, what do we get? Another delay. So it's not just the courts. We have, the courts are congested, especially the Court of Appeal and the Supreme Court, even the High Courts. And then we are waiting for arbitrators to do their job, to read the law very, very well. Arbitrator is hoping when if I did not give the award, I can extend the time to give part of the remaining award, or I can extend the time to make the correction. The law is that you can extend the time to make the correction. So why wait to make that correction at that particular point in time? You have 3 months to do this before the 3 months. You can sit down and look at these things. And why in a hurry to push out that award? And why give that award to only one party? Publish the award whether you've been paid or not. Not everybody is there. If you start looking for money, how much you are paid or this and that, I don't know. Because since the law is saying push it out at this particular time, you write the award, people know that you've written the award, or one party knows that he has written the award, maybe the person that has paid you. It is very, very clear. And there has to be a date on the award. So that date on the award, how do you change it? You have already published the award. How do you change it? These are some of the things that cause the delay, not just because the courts are congested, not because the judges are sitting on the whole thing as if they are sitting on appeal. No judge will want to sit down and sit on appeal over this kind of thing. He's looking, the judges, well, if there's some judges are doing that, the judges are really looking at the award before them. So if they decide to do as if they're sitting on appeal, well, what can anybody do? Now, we have said that Lagos State High Court, multi-door court, is my multi-door court. I admire them so much. Some courts in the states, let me not mention names, are not even funded. The judges, they have only 2 judges. I know it said that has only 2 arbitration judges. We say, oh, well, let me get on with the cases I have. After all, this is an arbitration course. I want to generate my returns for the quarter. Only 2 judges. And these 2 judges come there, all these delays, delay here, delay there. Misconduct on the part of the arbitrator and all that. So let me round up by saying, if the arbitrators can look at the ethics, is there in the ACA, look at that, the ethics, and know what they should do or what they should not. If you know a particular party, please recuse yourself. And there should be a disclosure If you know that, I mean, you can't get on with this, there will be other cases to arbitrate. Why must you get on with a case where you know that you know the parties? The parties may not talk. At the end of the day, when they go on appeal to the High Court, they will talk. And at that time, it's a bit too late. The whole thing is delayed all over again. This is what I can say. Meanwhile, if we're asked to speak again, I'll come up with that.
Thank you so much, Honorable Justice Theresa Uzokwe, retired, former Chief Judge of Abia State. Thank you, Uzokwe. I apologize, my lord, former Chief Judge of Abia State. Thank you for that practical, exposition of the issues with our arbitral award. We are most grateful. Can we call on the next speaker, Honorable Justice A.M. Lawal, fellow, Nigerian Institute of Chartered Arbitrators, and a fellow judge. My lord, please, the floor is open for you. We are eager to hear from you too.
Good morning, my lord, Honorable Justice Ayotunde Phillips, CJ Emeritus. It's good to have you around, ma. Good morning, my lord and my teacher, Honorable Justice Theresa Uzokwe, former CJ Abia State. You taught me how to deliver as many judgments as possible within a month at the 2014 NJI induction.
30 judgments.
What I picked from you is what I still use up to today. Good morning, Mr. Agbola Lanesek, for a well-researched and beautiful presentation. Good morning, participants. I want to share my personal experience. The point of view of a legal practitioner, even though I'm not one. Perspective. Shell and Imani cases, my former office was involved in it. So after the Supreme Court confirmed the award, the client still came to us. Lawyers, please find something to file. This money is much. So if the award is executed, my company will collapse. Before we could say anything, say you have spoken to another senior advocate, and this is what the senior advocate said can be filed, can be filed. So he forced us to file something at the High Court again, after the Supreme Court has given award, confirmed the award. So when I appear in the matter before my Lord Justice Olateru Olabegi, said, Lawal, which motion is this? He said, I'm sure your principal is not aware of this motion. So what I'm driving at is that some of these bottlenecks are from the client themselves. They will tell you what they want and what you should do. So a counsel should be able to stand firm and say, look, this is wrong. It's professionally wrong. So a counsel should be able to stand there. So most of the time, the client pushes the counsel. And at times, the counsel, because of the money, they collect appearance fees. So they find one thing or the other to file. They file their processes, they collect money per processes they file. And some of these things causes delay. Another aspect of delay is from the arbitrator themselves. Because they are on their own, so to speak. There's no professional body that seriously sanction misconduct. So some arbitrators misconduct themselves. I was involved in an arbitration where our appointed arbitrator called us and told us this and this is what's happening. They prepare a ruling and ask her to sign. They never discussed it, no position was taken. I cannot sign what we have not discussed. Let's discuss it and take a position. Either we grant the application or refuse the application. They said no, they have made up with their mind. That's what they're going to do. Literally, after she went through it, the position is against us, and she could not find reason why they should go against us. So we have to file a motion at the High Court to get the arbitrator removed from misconduct. So at times, it is not just the counsel. Some of these things come from the litigants themselves, from the arbitrators. Then as a judge, I've handled quite a number of arbitration, appointment arbitrator, or enforcement or setting aside. I started in general civil, so where that decision that handled arbitration. There was a particular matter. Everything was set, applying to enforce the award. The other side has filed a counter affidavit. So the reply on point of law was filed. I fixed it for argument. The counsel came, he said he has not read the reply on point of law filed by the judge, by the award creditor. He said, need time to read. Okay, no problem, I'll give you a date. We suggested all dates, or every date is not complaint to the counsel. Okay, where will be on this date? He said, I'm at Federal Court. All about that date, I'm at Supreme Court. So he mentioned in particular, they said, we'll be at Ikorodu High Court. Okay, no problem. Go to Ikorodu. I'll wait for you at 3 p.m. Come on that day. On that day, they didn't come, wrote a letter, I'm sick. So these are the kind of things that causes delay. So the delay could be at the instance of the litigants, caused by the arbitrators, conjured by the counsel, and from the bench as well. We're a human being, the judge can fall sick. A judge can go on a national assignment. There could be any foreign holidays, public holiday. All these causes but essentially it is more on the part of the counsel. From my view, it is more on the part of the counsel. Then I have one or two things to chip in. The paper is okay, well presented, and duly researched. Also, I want to talk about customary arbitration. There are two methods of enforcement of award. As award on enforcement under Section 31 of the Arbitration Act. And at common law, award can be enforced by an action on the award. So where the arbitration agreement, says in the event of disputes, arbitration will be done in line with the Arbitration Act or in line with the UK Act. So after the award is done, concluding award is granted, they can file an application in court for the enforcement of the award. I heard people saying that award should be extended to criminal and other aspects of the law. There's no problem about that. And it can be enforced, but not under the Act. It can be enforced at common law by an action on the award. Now, by filing a writ, you file a writ, you plead that so person was the appointed arbitrator, and this is his award. So the award can be in writing and it can be orally. Maybe a family dispute, this family against that family. So they mutually submitted to maybe the head of the village, the Bale or the Igwe. They listen to side A, listen to side B. Maybe a dispute on land, okay? But what you have said, it is side A that owns the land. So after that, they can file an action to enforce the award given by the Igwe or the Bale. So what they need to do is to plead and prove that the two sides voluntarily submitted to the arbitrator and the award is final, and that the proceeding is in line with the trade or the custom of the people. So if that is done, it can be enforced by court. So if there's any criminal matters, for instance, now can be submitted to an arbitrator. Maybe somebody steal my items. I caught him instead of going to court and the police. Okay, look, let's go before XY said. He will listen to the two sides. Okay, well, it is true that you have stolen the car and you sold it. But since you sold it, the value of the car is 2 million. So you should be paying 300,000 per month for the next 6 months until the full value of the car is completed. So that kind of discussion, if there's a breach, it can be enforced by filing a writ. So that is what I've got to say to the discussion. I thank you all for listening.
Thank you.
Hilda, you're muted. Unmute yourself, Hilda. Unmute yourself, you're still muted.
Unmute myself.
Okay.
Okay, thank you so much, Honorable Justice A.M. Lawal, for that incisive, discussion on the topic at hand. We are really very grateful. On that note, we are going to go to the next segment of this program, which is the question and answer session. Like our Honorable Registrar has said, we are not going to take individual questions. We are going to start on the questions on the chat box. As we take them, I know our renowned panelists are very well and able to answer those questions. So permit me to read out the first question. Our panelists are there to take them. The first question is, could parties choose a court of enforcement prior to hearing of the case? Let me not be the one that will call on the panelists that will answer each question. My Lord, the Honorable Justices that have taken the matters will, whichever of them that chooses to answer the questions can please go on. I'll take the question again. The question is from Folahan Olorede, and it says, could parties choose a court of enforcement prior to hearing of the case?
I think that question is for Mr. Agbola, really, not for us.
Yes, thank you.
Thank you. Okay.
Yes, thank you.
Yeah.
Yes, the concept of arbitration really is about party autonomy. It's about the parties agreeing as to what mode they want the matter to be arbitrated. So conceivably, the parties can agree in their submission to arbitration, either in their agreement or at the preliminary hearing, that any matter that is going to arise in this matter will be limited, will be challenged or enforceable at a particular court. And don't forget, when it comes to the issue of jurisdiction, parties cannot by themselves confer jurisdiction on a court. If a court does not have jurisdiction, it is going to be difficult for the party to say we'll give jurisdiction to a particular court. But theoretically, it is possible either in the agreement for submission to arbitration or by agreement at the preliminary hearing to say If there's any dispute as to this nature, the dispute will be determined by reference to this particular court. It is possible. And in the same way, because of the issue of, I just use the opportunity to answer another question, which is the issue of having the matter going all the way to the Supreme Court. Parties can actually agree that any challenge, that the final court that will determine a matter will be the High Court, that any challenge, whatever decision of the High Court is on the matter, should be the end. It is theoretically possible by agreement, because it's the parties, you are in arbitration is an agreement between the parties. Both of them have agreed. So the problem is that people normally leave most of this issue until there's a dispute. If these matters are settled before there's a dispute, that in case of a dispute in this matter, the seat of arbitration will be so. Most agreements simply say, oh, it will go to arbitration. They don't state the number of parties, or the number of the arbitrators. They don't state the venue. They don't state the seat of the arbitration. These are matters, but if you have a competent arbitrator at the preliminary hearing, most of these issues will be determined so that parties will know exactly where they stand. So theoretically, it is possible, but you cannot convert jurisdiction in a court that does not have it. So even when you are choosing, you must still choose a court with jurisdiction in the matter. Thank you.
I would like to chip in on that.
Thank you so
much. Parties are
Go ahead.
Thank you. Parties
Honorable
are
Justice Lawal.
Thank you. Parties at times do make a choice of a court, but in practice, the court will assume jurisdiction if that court has jurisdiction. The court will not assume jurisdiction if, even though that is of the arbitrator. So that's the decision of the court in RZB, one Austria case like that, RZB, I've forgotten the other name. In reality, you take your award to where the judgment debtor has assets. So if the award was awarded by an arbitrator in Ghana, and the defendant, the award debtor, is a Nigerian company with assets all over Lagos, it is prudent to come to the High Court of Lagos or the Federal High Court for the enforcement of the award. If you go to Abia High Court and the award debtor has no property in Abia, so there is nothing for you to do there. So you take the award to where the judgment debtor has assets. And about the jurisdiction of Federal High Court and State High Court, so my take on that is that I've written a judgment on that, Bagadia and Churchgate. Well, the issue was raised, and a particular decision of one of my brother was cited for me. I disagreed that Federal High Court is a court of enumerated jurisdiction. It is stated in the Constitution that this court has exclusive jurisdiction on the following list: companies, aviation, admiralty, foreign exchange.
Looks like my Lord's network is not stable right now. Okay.
So arbitration is not.
I like just
I can hear him.
We can hear him. I can hear him.
Maybe it's your own network. Maybe it's your own network.
I hear him clearly.
Maybe it's your own network. Okay.
Oh, okay, go ahead. Go ahead, my lord.
Okay. So arbitration is not stated in the Constitution as being exclusive to Federal High Court. The Arbitration Act gave us option. It said High Court, and High Court was defined to mean Federal High Court or State High Court. So that was my ruling. That was my decision on the judgment. My view is that because arbitration is not stated to be exclusive to Federal High Court, even though the dispute is admiralty, that my business is not to decide the admiralty dispute, but to enforce an award. That the Constitution did not make it exclusive. They don't make arbitration exclusive to federal high court. So I refuse the argument of the award debtor. So for the enforcement award, the courts, the parties cannot really make a choice. Rather, they should go to where the asset of the judgment debtor is. So even though one has a domestic award in Nigeria, in Lagos, if the judgment debtor has asset in Kenya, you take it to the high court in Kenya. So provided we have a reciprocal enforcement treaty agreement with Kenya, you're going to enforce in Kenya. But it's be foolhardy to have an award in Lagos and you go to Cameroon simply because the company is a Cameroonian company and if it has no asset there. So parties can seek for the enforcement of the award at where the judgment or the award debtor has asset. Thank you.
Okay. Thank you so much, Honorable Justice Amen Lawal and our revered Silk. Because of time, will I quickly go to the second question? The second question says, how do you view plea bargaining vis-a-vis the concept of arbitration? Let me take it again. The second question is from Hamza Haladu Esquire. And her question is, how do you view plea bargaining vis-a-vis the concept of arbitration?
There any such thing in arbitration? Arbitration usually handles civil matters mainly, but I don't know.
Well, I don't think that, sorry, my lord, I don't think that question is a question we want to take right now. We will, plea bargaining does not come to play in arbitration. Because of time, I would ask that we restrict ourselves to purely arbitration related matters. You know, I would just ask some questions from here as well. These questions, I think, are from the comment section. It says, what remedial actions recommended where the arbitral award is not communicated simultaneously to all the parties? What remedial action do you recommend? I think this question is to the learned sick, Mr. Agbola.
Thank you so much. As I said, one of the steps that are not really that is really necessary in arbitration that can speed up the process and is underutilized in arbitration in Nigeria is a preliminary meeting. The preliminary meeting should set out exactly the calendar for the arbitration. And even if it is not done, at the close of final hearing for the arbitration, there should be a date set by the arbitrator for the award. Once that is done, of course, all parties are enjoined to monitor that date so that if on the date the arbitrator stipulated that is going to release the award and that award is not done, I believe it is easy for the parties to contact the registrar to the arbitration panel to find out what is causing the delay. So I think that is a very simple, it's just a matter of keeping in touch because most arbitral awards will be ready by the date it is promised. And if it is not ready, the arbitrator is under a duty to notify parties of any delay in the award. But the usual reason for the delay in publishing award is because of non-payment of fees. So, but that also, there is remedy for that, because if one party refuses to pay, and after a demand has been made by the arbitrator, he can call on the other party to make the payment. So if all monies have been paid, nothing is outstanding, there's absolutely no reason why the arbitrator should not publish the award on a date he has fixed or on any other date. Don't forget, this is a reputational issue. People are appointed based on their performance in the past. So it is important because I hear a lot of complaints from people that, since I'm a fellow, nobody has ever referred application to me. Well, it is difficult because people usually look for people with sound track record. in recommending, because if I'm appointed by a party, if I'm the counsel in a matter and we have appointed, I would normally recommend, and we have to choose an arbitrator if it's a 3-man panel. I would normally recommend somebody that I know has competence in the area to be appointed. And when I'm serving as an arbitrator, perhaps in a party nominated arbitrator, I always like to agree with the other party nominated arbitrator, is letting the chairman to let us choose somebody that I know will actually drive the arbitration quickly. So the remedial system is, because this is a commercial arbitration, usually people are very punctual. And if there's any delay, which is not caused by, I'm sure a call to the arbitrator through the registrar, we actually make things move fast. Thank you.
Thank you so much, Leonard. Still. Okay, if there is also another question, a third question, with the kind permission of the panelists, read it out. And the question is, are there problems with reasonable magnitude of awards by arbitrators? Let me take the question again. Are there problems with unreasonable magnitude of awards by arbitrators?
Well, that
question, are we together?
What do you mean by unreasonable magnitude?
It means very big award, very big award.
Oh,
well, usually in the point of claim or counter claim, an award, an amount is usually stipulated. You are making a monetary demand and say, I'm asking for so much money. So any award made within, if it's not, I mean, if somebody has 100 million and is awarded, you cannot say it's unreasonable. You may not agree with it. Don't forget, you choose your arbitrator. That is the most important thing. You are the one who chooses this is the method of arbitration you wanted. So if the arbitrator haven't considered all the matters, that is why it can be very dangerous. So I always tell people, be nice when you are appearing as a counsel in arbitration. Be nice to your arbitrator. Be courteous, because whatever decisions is taken, from experience, from record, from statistics, will be confirmed by the court. So about 2 years ago, an award was made, and in Nigeria, $1.9 billion. That's the award. We can't say it's unreasonable. So any award made within the scope of the what is submitted for arbitration cannot be said to be unreasonable. So the issue really, there are some. I even thought you were going to talk about fees being charged by arbitrator. That some fees are unreasonable. Well, it's a matter of perspective. I've gotten, there's a matter where we were charged 500 million by the arbitrators. Well, we all ran away because that 500 million, now if we had it in the first instance, perhaps we will not go to arbitration. But that is a matter of commercial interest, because both the arbitrators and the claim and the people coming to arbitration, because your fee is a function of what you are claiming. If you choose to claim 5 billion, the arbitrator doesn't know whether you are going to succeed or not. Benefiting his fees. His job is not contingent on your winning. His fees is not contingent on your winning. His I charge based on the claim you have filed. I don't know whether you succeed or not. The institute has a guideline for fees. That guideline is based on the fees. You go to the UK chapter, it's the same thing. So if you don't want a high fee, don't claim a high amount. It's as simple as that. But when it comes to the award itself, the damages or costs or amount recovered, it's a function of what you claim. So there's nothing like to say an award is unreasonable. No judge will review that amount if it is within what you submitted to arbitration. Thank you.
Can I come in here?
Yes.
Can I come in here?
Yep. You're welcome.
Yeah, I am wondering if in making the award, the arbitral tribunal states in the award their reason for the huge quote and quote award they give, would there be any complaint? I believe that if there's, if it's not stated, the reason for giving such a huge award, there ought to be some sort of complaint. So I'm suggesting that that reason should also be there in the award. It will enable the Court of Appeal, if anybody goes on appeal, understand why such a huge award was given. Thank you.
My Lord Justice Phillips, Emeritus, I'd like to pose this question to you. It's a question that is personally directed to you, my Lord. Okay. It says, by virtue of insights, are there things you would have done differently as a judge with the benefit of a sitting arbitrator? In particular, how can we use award of interest and cost to mitigate the endemic attitude of appealing to set aside an award, as Mr. Agbola, SAN, has recommended, in view of the UK cost that he mentioned during his presentation?
All right, yes. See, this involves a total reorientation of the mind of the practitioners, both the arbitrators and the counsel.
Hello, my Lord.
Can you hear me? Can
yes,
you hear me?
We can hear you.
We can hear you very well.
Yes, my Lord. Did you get the question, madam?
Yes, I've started to answer it. Yes, I understand the question. It involves, you see, the mindset of all the parties, all the players in ADR now is, let us just transport what we do normally day to day in courts to the ADR process, which is wrong. ADR is supposed to be a more efficient and speedy way of dispensing of these disputes, especially, more importantly, in commercial matters, which affect the economy of the state or of the country. Having said that, the only way now, that's the benefit of hindsight now, maybe in my court, because I can only adjudicate in my court, and those who want to copy will copy. Maybe if I had awarded heavy costs here and there, but even with the mindset of the lawyers, that's going to be another ground for the appeal to the Court of Appeal. We need, you see, even we judges, both serving judges and retired judges who are now arbitrators, we need to really sit down and come to an agreement as how do we handle these matters. If the president of the Court of Appeal could kindly allow a few of the justices of the Court of Appeal to be trained in these matters, so they know the importance, they know the speed, they know how valuable these judgments are and these matters are to the economy of the country. Train them that, look, when you see these matters coming from the Federal High Court, from the State High Courts, treat them quickly and dispense with them. And as Mr. Agbola suggested, if possible, let the termination of all these matters be in the Court of Appeal at the very worst. So, but that would need an amendment of the law. It's a federal law. It'll have to go to the Senate and blah, 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 blah. Do you understand? So this is a very good question in that this could be now the basis.
Thank you, my Lord.
For us to have a rethink. We need to have a rethink.
Okay.
Have I answered the question?
Yes, my Lord, you have. In fact, my Lord, you've just taken this out of the mouth of the Institute. We're actually planning a roundtable for the judges, including the Court of Appeal judges, to look into this issue that's made challenged against award. And I'm going to be calling on you, my Lord, once we are set, to also lend your voice to the roundtable that we intend to have for the judges, because we can see that the challenges and difficulties with arbitration in Nigeria is multifaceted. We have the issues from the lawyer's perspective. We have the one from the arbitrators,
judges,
and then particularly the one from the judges. I think for the one for arbitrators, we can handle, Nigerians can handle our own band of arbitrators. We don't know about other institutes. But for the one for the judges, I think it has to do with having to sit with the CJs and the president of the Court of Appeal, as well as that of the National Industrial Court, to say, you know what, we want to be able to train the judges to understand the nitty-gritty of arbitration, why it is very important. They do not treat arbitration matters just like any other matters or cases in their dockets. So this is something we're going to be doing, and we will be calling on you, my Lord, to join us in this crusade. I'm sure that once we're able to get arbitration going as it ought to be in Nigeria, we'll have more cases, more people will want to use Nigeria as a jurisdiction, and we won't need to do all this fight of, why are you not allowing Nigeria, choosing Nigeria as a seat? It will come automatically. So it means that we have a lot of work to do. We need to clean our system in-house. So thank you, my Lord, for that contribution. Hilda, you may want to ask other questions, but please let's take the questions and the other priorities because of time.
Okay. So can we take, because we still have some time, can we take one more last question before we conclude?
No. I'm not saying we should conclude. I'm just saying take the questions in priority so we treat the most important ones.
Okay, thank you, Madam Registrar. Yes. Please let me take the next question. The next question is from Frederick Olusegun Bolaji. And his question is, are there no remedies open to an arbitrator to recover his fees rather than the rather inglorious choice of not publishing or communicating the award to the parties? I think one of the honorable justices has answered this question, except we're going to recap it again. The question says, are there no remedies open to an arbitrator to recover his fees rather than the rather inglorious choice of not publishing or communicating the award to the parties? I leave it to my Lord that earlier talked about this issue.
Hilda, I don't think this question is directed to my Lord. You understand? This question is something that is clear to all of us as arbitrators, and we want to respond to it. The starting point, when we do professional ethics, we train arbitrators. This is one of the issues we treat under professional ethics of arbitrators. And we always make it very clear that before you commence a proceedings, collect your money, at least a deposit. Don't start without getting a good deposit, so that when you have this kind of issues, you're not going to be affected. And where one party is not willing to pay, particularly the respondent, get the claimant to pay for both before you start. So once you do that, then you are okay. But where is somewhere, because some arbitrators are excited and they just go ahead and commence proceedings without collecting their money, they will run into this problem. And the other point we want to also say is that, like my Lord mentioned, some claimants and respondents are very funny and tricky. When they file their points of claim and points of defense, they won't tell you the amount involved. They will only release a little bit of it for you because they want you to fix your fees and they want to hold you to it. So as a smart arbitrator, what you will do is tell them, well, this is what you have put before the tribunal. But if there's any change in your claim, any review or additions, then the tribunal will review its fees. So the issue of fees is not really a big problem for us in arbitration, according to what I know, except where the arbitrator is not very smart in terms of collecting his or her fees. So that's the answer to that question. Then you may want to ask another question that my lords and the learned can respond to.
Okay. I don't know, from the chat, that's the only 4 questions there. I don't know if we can allow, if Madam Registrar, you have any other topical, any other very important questions, because it's not easy to gather the caliber of learned and judges, both retired and serving we have here. If there are other questions that will come from these two sides, let us take 1 or 2 of them before we start winding down.
Okay, thank you very much. I just want to do a recap. I'd like to ask Honorable Justice Phillips to please share more light, You were talking about customary arbitration. I kind of like, I was very excited when you're talking about the fact that you can enforce your award under the common law. But, and I'm now asking myself the question, under customary arbitration, does commercial disputes or commercial arbitration, does it fall under customary arbitration? Because we need to understand, so we don't have a show where lawyers that are listening to this webinar think that, oh, we can use customary arbitration to enforce an arbitral award that has to do with a commercial dispute or a commercial transaction. So my Lord Justice, well, I want to throw more light on that additional way of enforcing arbitral award.
Thank you, moderator. The principles that I've stated is, if there's an arbitration agreement, that in the event of a dispute, it should be governed by the Arbitration Act or Arbitral Law of Lagos. 3 arbitrators will be appointed. Then you do arbitration, you get an award, then you come back to the Arbitration Act, Section 31 for enforcement. But if there's no written agreement, or if the agreement is silent as to arbitration, there's no provision for arbitration, the parties can agree to arbitrate. It need not be formal. Like a village, maybe this village against the next village, fighting over some hectares of land. They can go to the neighboring village, the cabinet of the neighboring village. We have a dispute. Or even the man himself, the cabinet may invite the land that your village and the other village are disputing land. Come to me on Friday, so let's discuss it. So the 2 villages send representation to the KBC. After listening to the 2 sides, it decides that the land belongs to village A. So that is arbitration, but it didn't go to court. But in this case, there's no arbitration agreement. But the KBC has awarded the disputed land to village A. So to enforce the award, village A will get a lawyer to file a writ of summons and plead that this is the dispute. We went to the KBC of the neighboring village. He listened to us. The 2 sides submitted to the KBC, and this is what the KBC decided. So the court will enforce the decision of the KBC. That's how it is done by common law. It is the provision of the common law. It is not in the Arbitration Act. If there's no prior arbitration agreement and parties eventually got a third party who sat between them and resolve the dispute, so the award or decision of the third party is final and binding, and it can be enforced. So instead of going to court to claim the land, declaration that Suso village is entitled to Suso land, you start proving title to the land. We are the first settler, or we bought it. These are our documents. This is our history. How we migrated from Suso place. Our forefathers settled here 200 years ago. That's not what they're going to prove. They have already established that before the KBAC. What you need to prove is that there was a dispute. The 2 sides went to the KBAC, and this is the decision of the KBAC. You also have a page pleadings. You can summon the KBAC as a witness. You do witnessing or not for you. You summon him by subpoena. You will come. Also, date I had there was a dispute between the 2 villages. I asked them to come. The 2 of them came, and I resolved it. This is my finding. So the court will enforce it. So that's how to go about the enforcement of a customary award. So it is not limited to commercial issues. It can be all manner of disputes, even plea bargaining. If there's a crime, as I've said, somebody steal a car, and a third party called it. They say you stole the car. I say yes, I stole it, but I sold it and I spent the money. The car is 2 million. How do you pay? I can afford 200,000 per month, and it's acceptable to the owner of the vehicle. So that's settled it. If the man did not pay as agreed, he filed a writ. So instead of claiming that he stole, you are the owner of the car, this is the price of the car, you don't need to prove all that. What you need to prove is that there was a discussion, a third party came in, and they pronounced an award that 2 million should be paid by installment of 200,000 per 2 months. So it can be used for all manner of dispute: commercial, contract, criminal, family, land, anything, chieftaincy. Thank you all.
Thank you, my lord. This is a good one.
I want to chip in. I want to chip in something, Shola. When the judges went to Rwanda in 2013, we learned from them that they said, you know, there was a lot of genocide in Rwanda, where they were killing each other.
Yes.
So we asked how they kept all the bones. We saw all the bones and all that of the dead people. So we asked the question, how did you manage to get peace after all this? They said they used their own native arbitration. People just went, if they'll go, they'll appoint a leader in the village or the tribe, and they went there, they confessed their crimes, apologized to the families and blah, blah, blah. And that's how they settled the matter. Purely arbitration, not by going to court or any such thing, but just by traditional means of settling their quarrel, which we have here. We have it, like Justice Lawal has just mentioned, by going to the Oba or the Bale or the Eze or the Emir. They seem, in the north, they seem to prefer going to the area courts with their problems than coming to the high courts. The high courts are empty, but the area courts are always packed full. So I think we need to dig deep into our judicial system here. A lot of work needs to be done, so we can find a way, a much better way, a much more effective way of settling these disputes. And we need it now, like I said, that the courts are too congested. Justice Lawal should bear me witness whether I'm not speaking the truth. They're too busy to handle all these matters now.
Yeah.
And a lot of the files, you know, the High Court was destroyed. See, show me your files. Show us your files, Mr. Justice Lawal. Can you see? Can you see a judge's table? Can you see? Show me. APR is the way out. That's the only way out. And we're messing about with it. So please hurry up with your round table. It's very, very important.
If I may come in here,
Madam,
can I come in here, please?
Yes, my lord.
Yes, ma'am. Yes, Justice.
What Mr. Lawal just said is what obtains down east, where I am. The people here are quite smart. You know what they do? There's a land dispute. They don't even need to go to the traditional ruler. The parties know who is telling the truth. When they are tired of fighting and they're destroying crops, what they do is to get a young lawyer somewhere to file something, a little writ in the High Court. They file the writ, then they write an agreement. I was surprised to see one. This was just filed. Then an agreement already written, a settlement agreement, or they call it consent judgment. They bring it to the court. And then the lawyer stands up to say, my lord, we filed this thing, but the parties have settled. Party A, about 3 of them, party B, about 2 of them, they're here they've signed the settlement agreement and they want this to be the judgment of this particular court. They are here to identify their signature. What can you do? You say, okay, identify your signature. They will identify. It's read out, so-called agreement is read out by the court. It is, the lawyer tenders it as exhibit A, the agreement, settlement agreement or consent judgment of the people. Then the judge makes an order, maybe there and then or whatever, makes an order and it becomes a judgment of the court. But you have to write something, how they came and all that. It wouldn't take 30 minutes while other people are waiting. They've been doing it down east for a very, very long time and it works out. They don't have money for lawyers. They can't go to the multi-door court and spend days there. They can't go through the proper arbitration process. So they do it. It has been happening and it's succeeding down east.
Okay.
Yeah, yes. May I just there are some questions on the panel that we have not really answered. So perhaps I just quickly run through them before that. There is a question from Mr. Frederick Bolaji that there is an assumption in this discussion that it is only lawyers that are involved in the arbitration process. I'm sure that is not. I did mention it that the arbitrators can be accountants, can be engineers,
Architects.
can be architects.
Yeah.
But usually when it comes to the enforcement,
Mhm.
when it comes to the enforcement,
That's the lawyer.
I can assure you about 99% of it will be done by lawyers.
Oh, yes.
So perhaps that is why the discussion towards what lawyers do or what they don't do. So apologies for that, but it doesn't, it's highly unlikely, unless the engineer or accountant architect is a party to the arbitration. Of course, like any other person, you don't need a lawyer to come to court. If you can take the risk yourself and follow the format, anybody can file an action in court. You don't need to be allowed to be able to do so. Now, there is also a question by learned brother Sik, Professor Brother Sonny, asking that what sanctions can be levied on a lawyer who keep on challenging jurisdiction from one court to the other. That is the one who challenge the jurisdiction in the state high court. The matter is referred at the federal court. It goes ahead and challenge. Well, unfortunately, this is a matter of professional ethics. People get away with blue murder here when it comes to professional ethics. And I cannot remember that there is a judgment, a very eloquent judgment. I cannot remember the citation now, but I remember what the judge of the Supreme Court said about somebody. It's a matter involving Adeleke. And the matter, recovery of debt, was filed at the federal court. He objected. It was withdrawn. It was not withdrawn. It was the federal court now referred to the state high court. He filed a similar application at the federal court, at the state high court, and so Lagos State High Court does not have a decision. And the judge, my Lord Judge of the Supreme Court said, what kind of person are you? This matter has been in court now for more than 10 years. You have not even filed a defense on the merits. And yet you have been filing only on the issue of jurisdiction. So I think this is more of a failure of our disciplinary mechanism than it's not just limited to arbitration. Because if lawyers are disciplined the way it is done in New York or the way it is done in UK, you can't do that to a judge in high court in UK. You will be sanctioned. You'll be removed, no matter how early place you are. But this is Nigeria, almost anything goes. And I'm sorry to say, a lot of our judges have become so timid in recommending disciplinary actions because every judge has an inherent right to discipline a lawyer. It doesn't matter whether you're a senior advocate or whatever you think you are, you can discipline a lawyer and recommend him for discipline. But you hardly say a judge recommending that the lawyer be disciplined nowadays. The lawyers keep on writing petitions for real and imagined crimes against the judges. They keep on writing. Even a matter that should go on appeal, they would rather prefer to write a petition. That is the kind of things that we are witnessing. So there is also, I think those are the two questions. And my Lord, on the issue of customary arbitration. Yes, it is allowed, but that really does not come under the remit of the ACA, because it's like any other agreement. Parties can buy, and my Lord Justice Uzokwe has also mentioned about the consent judgments. That is really not, people can agree among themselves. Arbitration is rather a more formal process, and the requirements are very strict. But customary arbitration is allowed because if both of you agree to submit yourself to mediation or arbitration by somebody else, you are of course banned by that decision, if that is what both of you agree to. So it's a function of the procedure, because I've had people say, oh, whether you can arbitrability is also an issue, because people are saying, can you arbitrate criminal issues? With all due respect, I don't think so. No. Because arbitration connotes an agreement to do something. That arbitration is limited usually to commercial disputes. If we agree, we have agreed that if this thing happens, this is what will happen. Even when you file a matter in the High Court, if both parties, even after you have filed the matter, if the judge suggests, oh, gentlemen, these matters can be resolved by arbitration, it's not going to be faster. If both parties agree, just like what we do in the Legal Mediation Center now, you can just fill a form and both of you submit. You can go before the arbitrator, and whatever you agree upon become the judgment of the court. Those are special cases. But the common one that are involved in commercial disputes, the agreement must have stated so. before even disputes arises. You can, of course, you can also agree to arbitration after a dispute has arisen, but that would demand some monopolism, because if you already are in dispute, it's highly unlikely you will agree to go to arbitration, because arbitration involves that. I don't want to waste my time. So those are the issues that we should not, when we are talking about crimes is not something that is subject to arbitration. Otherwise, unless you are saying that people have agreed that to come and steal my property, and I've agreed that when you steal it, I will not report it to the police. I would rather take you to arbitration. Those are two different things. Because crime is a state issue. Your offense is committed against a person, but it's the state that prosecutes it. So you are not like the issue of going to arbitration does not arise on that. You can have the clear bargaining they'll be talking about. It's only about, oh, I don't waste my time. We want to make.
Thank you, Mr. Agbola. I think our time is fast spent. And
yes. Okay. We have just 1 minute more. What's that going to the next one? Hello. On this note, I hope people can hear me. Okay.
Yes, we can
On
hear.
this note, okay. On this note, time is fast spent. I cannot thank the panelists enough, and so it will not be nice for me to say just one thank you. So I'm going to say thank you, gracias, danke, merci beaucoup, eshego, sanunde zua, dalu, meka, madigi. In fact, but for the 1 minute more, it's 12:30, I would have continued. So I say a very big thank you to the learned SN, Mr. Adeleke, Agbola SN, Honorable Justice Ayotunde Phillips, retired, the former Honorable Chief Judge of Lagos State, Honorable Justice A.M. Lawal, Honorable Justice Theresa Uzokwe, not the last. And I also thank our registrar, Shola Osho, such an insightful, and enlightening webinar for practitioners, for those who practice arbitration. You all agree with me that enforcement of domestic arbitral awards has been a very big issue. In fact, it's not just to sit, but to enforce them. So on that note, I'm going to, if the registrar does not have any other thing to say, I'm going to call on one of the participants to give us.
I don't know if it's my network or Hilda's network, but I think she's having some challenges here. Because Hilda, thank you very much. Now we are having technology issues, so we need to close this webinar right now. So I just want to lend my voice to all the thank you, my lords. Thank you, distinguished SAN. Thank you to all our members that joined from all over Nigeria, within and outside. See you for the next webinar. I also want to say thank you, my Lord Justice Phillips, for waking up at 4 a.m. to participate in this webinar. Ma, I will be knocking on your doors to ensure that we're able to pull through some of these things we've discussed here today. We are all positive about a change, progressive change in the jurisdiction of arbitration in Nigeria, and hopefully with you being out there, also not just an arbitrator, but also being part of the International Court for Sports Arbitration, we will be able to bring about the necessary changes that we require. I also want to let everyone know that, yes, the Arbitration and Conciliation Act is due for a review, but we're having issues. Typical Nigerian, the act has been there for so many years. This is the second time we have brought the act before the National Assembly, but nothing has happened. Hopefully, maybe before they leave next year, something will happen. But if not, we will, within our own capabilities, try and bring about the necessary changes that we need to have. And Hilda, I believe you are part of the NBA. For those of our members who are part of the NBA, you occupy executive position. Please get the NBA to do something with our lawyers. The challenges we face, the NBA also can discipline and sanction lawyers when it comes to issues of, wasting of time of the court or trying to just become a yes person to the parties. The beautiful thing about arbitration is that even though a party employs you, you are not accountable to the party. You are accountable to the tribunal, ultimately. And so that is what we expect lawyers to do as well. So thank you very much, my Lord. Thank you, Hilda, for your wonderful moderation, and for everyone that has made this a success. Admin staff, thank you so much. Do have a wonderful day. Thank you. Bye-bye.
Thank you.
Bye.
Thank you.
Bye.
Bye-bye. Thank you, my lord.
All right.
Thank you.
Thank you, my lord. Bye.
Thank you.
Thank you,
Sorry,
everybody.
Justice.
My sister,
Thank
bye.
you for waking you. Bye. Justice is okay.
Just-
Bye.
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 Bye, Mr. Adeleke. Bye.
Always shining.
I'm going back to sleep now.
Thank you, my lord.
So
Thank you
sorry
so
for
much.
disrupting
I
your sleep.
appreciate you. Thank you.
Bye-bye now.
All right, bye. Bye.